Okay, hello everybody. I have 12:10. We could check real quick and see if we have staff and our advisory committee back on the call.
Should we have the advisory committee members just say a quick hi if they're here? Always great, always much appreciated if folks have their cameras on as well. Thank you, Melanie.
Hello. I suggest we take roll call again just to ensure that there's a quorum after the lunch break.
Yeah, that's a good idea. Richie, are you available to do that, or do you want me to do that?
Sure, I got it. Hanson, Chu. David Weiss.
Here.
Melanie Delgado.
Here.
Leah Farron.
Here.
Margaret Ryder. It's like Margaret and Canson are not responding.
Canson is here.
Oh, Canson's here. And Margaret? I see your mute or your mic is unmuted, Margaret, but I can't hear you.
Maybe she's having technical difficulties or it's taking a minute or two longer to get back. Richie, do we have a quorum in her absence, or do we need to wait for her to get back?
And she is on camera. I see her. She's waving at us right now. I think just figuring out the audio.
This is the moderator. We have a technical slide. If we could have slide 24 and then 25.
And I think, Debbie, are you okay proceeding, and Margaret can work on the audio issue? We have
yeah, I think that's great. I just think, I know most of these are discussion items and not for voting anyway. We just need to make sure that we have a quorum should the committee decide to take a vote on anything.
This is Margaret. Can you hear me now?
Yes.
Yes, perfect.
Great. All right, welcome back everybody, and let's continue on with the meeting, starting with agenda item 7 and 7A, which is an update on the January 24th town hall.
Great, and basically the entirety of this section will be led by Yvette Johnson, administration chief, and with Dave Dumble, who is our ledge and reg manager. Thank you, Yvette.
All right. So to begin with, on January 24th of this year, we held a town hall via WebEx. And the purpose of the meeting was to solicit early input on regulatory ideas and concepts from stakeholders. This event was well attended, and we had nearly 200 participants. A specific topic we discussed were the implementation of SB 802, regarding the definition of educational programs, and we wanted to get input on the minimum operating standards regulatory package that is now being drafted. With Senate Bill 802, it changed the definition of educational programs so that programs that include fewer than 32 hours of instruction and are not designed to lead to employment are excluded. This is a proposal we are moving forward with quickly, and which Dave will outline later. We also provided the draft text of the minimum operating standards for review and discussion. This has been a multi-year effort that started with input from stakeholders back in 2016. And we were happy to be able to share with the public where it stands now. Comments provided were being taken into consideration and our continued effort to draft regulations. We are currently planning on sharing the draft with the committee at our May 2020 meeting before moving it forward through the regulatory process. So anyone that was not able to attend the town hall meeting, the meeting materials are available on the Bureau's website. You can search the website by putting the word town hall in to obtain a copy of the memos and the draft regulations. And we continue to welcome your involvement in any other input that you may have and suggestions. With that, I'll now turn it over to David Dumble, our regulatory analyst and manager, to discuss the other regulatory items.
Yvette, if I could interrupt quickly, I think we're going to take public comment on the letter sections under 7 separately.
Okay.
And so, Mr. Dumble, were you going to be referring to the town hall specifically, or were you moving on to 7B?
Not specifically, I was going to go on to 7B. So it would be good to get public comments now.
Very good, thank you. We'll start with any questions that the committee has for Ms. Johnson about the town hall. I have a question. I was not able to attend, and so Yvette or Debbie, can you describe for the committee what participation looked like, how many attendees you had, and how it went?
I was trying to unmute myself. So we had over 200 participants, and we received a little bit of comment from some of the stakeholders. We're still, like I said, we're still requesting that if people were not able to attend, or if they have further suggestions, that they go ahead and send those in to us, because it was quite an extensive package to cover, especially the minimum operating standards. And so we want people to have input that is meaningful.
I would, the thing I would add as well is that, this was a new type of event for us. So wasn't really sure what to expect. I think, I felt good about the number of participants that we had kind of joining, and also that we did get some constructive feedback both during the meeting as well as after the meeting. So I feel really good about what we did, and hope we can do more. I know that that's kind of part of what we're trying to do in these meetings as well, just get early input to so that we are making as informed decisions as possible. Yeah, and I would say, just in terms of for this committee, or what we're thinking through between now and the next meeting is, I think, as Yvette said, a lot of the stuff that's in that minimum operating standards package, some of those things are issues that the staff have noticed issues with, places where there's contradictions between, state rules, accrediting agency rules, or what have you, or Department of Education, or places where there's confusion. So, a lot of what we were trying to do is really clear that up and eliminate confusion. So I think to the extent that anyone has feedback on specific areas where, where we haven't gotten it right, we're very much open to hearing that. That's exactly the purpose for why we shared it, because we want to solve for those problems so we don't keep having to struggle with these same issues going forward. So I do feel like from that angle, we did get a lot of constructive feedback and are continuing to get it, and just look forward to sharing that, the updated draft with you all in a couple months.
Margaret, I would also say, I really appreciate Debbie and the staff for putting that together. I think the more input you can get informally before we go to the formal process, the better. And so we've had that opportunity as committee members, but I think opening it up for the public was a great idea. A lot of times it seems to me, not with the Bureau in particular, but with some agencies, the whole comment process that's mandated is handled almost like a formality we have to get through because the law says we have to. And so I think the idea of opening things up on an informal basis like this was just great, and I appreciate it and look forward to others in the future. I know it's been a lot of extra effort for you folks to put something together to do that. So thank you.
Thank you. I thank you for saying that, Margaret. I think, it is certainly extra effort, and but I think a lot of it is if there are issues, and if we're making things worse rather than better, much better to identify that now rather than through the regulatory process.
Very good. With no other questions from the committee, we'll move to public comment on agenda item 7A, the update on the town hall held in
This
January.
is the moderator. We are now taking public comment. If you would like to make a comment, please type the word comment into the Q&A box, which should have appeared in the lower right-hand corner of your screen, and send that comment to all participants. For call-in users, please dial *3 to raise your hand. We will call on people in the order we have requests for comment. Robert Johnson is our first request for comment. Bear with us just a moment, and we will send you a request to unmute your microphone. We have sent Robert a request to unmute his microphone.
Good afternoon, thank you. On behalf of the association and a number of institutions that have contacted me, just want to let the Bureau know that we intend to submit written comments on a number of the proposed regulations. Just to let you know, the status of those comments is that generally there seems to be extensive concerns on the overreach or overbroad regulations as it relates to the statutes themselves. It seems to be a common theme in the calls that I've gotten is that it seems that these regulations go a bit too far. So that will probably be the context in which you're going to be receiving some institutional written comment. Just want to let you know. Thank you.
Next, we have a request from Angela Perry. Bear with us just a moment, and we will send you a request to unmute your microphone.
Hello, thank you so much. Thank you again for that helpful discussion, members of the advisory committee and wonderful Bureau staff and leadership. I just wanted to honestly pile on a bit more appreciation for this sort of first effort at this very open process, the opportunity for folks to share and give comments. And it was wonderful to have the Bureau. I know that it really must have been an additional lift and a bunch of additional work, but just sincerely appreciate all of the information that was shared and the opportunity to sort of participate in this regulatory process in this way is wonderful and great to see. So just wanted to, again, pile on just a little bit more appreciation for all of the work that I know went into that effort. And really appreciate that and the opportunity to offer comments. So thank you again, and thank you for all of the work I know went into that meeting and all of the regulatory packages that are underway. So thank you again.
Seeing no additional requests for comment, do you wish to close comments at this time?
Yes, please. Good, we'll move on to agenda item 7B, the update on the strip fee increase. And Mr. Dumble, I think you're going to lead that conversation.
Yes, thank you. I'm David Dumble. I am the manager for legislative and regulatory affairs at the Bureau. First thing I want to discuss is the strip fee increase, which at the previous meeting we mentioned we were applying for, and our application was approved by the Office of Administrative Law on January 12th. That will increase the strip assessment fee to $2.50 per $1,000, and that will be effective April 1st. We scheduled the implementation several months out in order to ensure institutions had sufficient time to make all the necessary adjustments. The Bureau has sent a notice to all schools about the increase after the OAL approval, and we will be sending another in the coming weeks. We've also posted a notice on our website alerting everyone to the change. So this has been approved and it's going ahead. Are there any questions?
Any questions from the advisory committee? As an institutional representative, I wanted to express appreciation to the Bureau for the orderly process for this, particularly in contrast, as you know, the last strip fee increase that was implemented, it was very rocky and insufficient notice, obviously, and even retroactivity that was very problematic for institutions. So thank you to Bureau staff for following a process that is practicable for the institutions.
The last strip fee increase was a legislatively mandated one, so we had a little less flexibility. But this one, we did try to take that into account.
Any other questions or comments from the committee before we go to public comment? Very good. We'll open public comment on agenda item 7B, the pending change to the strip fee.
We are now taking public comment on the pending change to the strip fee. If we have a request for public comment, please type the word comment into the Q&A box in the lower right-hand corner of your screen and send that comment to all participants. If you are a dial-in user, please dial *3 to raise your hand, and we will take comments in the order that they are requested. Let's take just a second now to see if we have a request for public comment. Seeing no request for public comment, would you like to close comments at this time?
Yes, please. We'll move on to agenda item 7C, which is the status of the application for verification of exempt status.
Just an update that this package was sent to DCA on February 1st, 2022. We had previously submitted this package last year, but after initial review, it was discovered that there was some need to retool some of the associated documents to move forward with the package. So that caused a delay. We've reformatted some of the documents, and we have now resubmitted the package to DCA, as I said, on February 1st. And by and large, it's still substantively the same as what was presented to you last year. And we are hoping to move forward now that DCA is doing its initial review. Are there any questions?
Hearing no questions from the advisory committee, we'll move to public comment for agenda item 7C, the application for exempt status.
We are now taking public comment on exempt status. If you would like to make a comment, please type the word comment into the Q&A box and send it to all participants. If you are a dial-in user, please dial *3 to raise your hand. We will call on people in the order received. Our first request for comment is from Robert Johnson. Bear with us just a moment and we will send you a request to unmute your microphone. Robert, we have sent you a request to unmute your microphone.
As a sector, we were surprised to see that the fee went from 50 cents per thousand to $2.50 per thousand. That's a 500% increase, which doesn't seem warranted based on the rate of accumulation to the strip based on previous collections. So that leads to the second comment that if you're making the students pay $2.50 per thousand in tuition, there is a limit at which you have to stop doing that, which I believe is 25 million. In the past, the Bureau has blown past that, and a number of years did not seem to be able to turn it off. So I would ask you
This is the moderator. We appear to have a connection issue with Robert. Let's give him just a moment to resume connection. Robert, are you still with us? Robert appears to be connected. His microphone is still unmuted, but we do not have any audio from him yet.
You want to put up that assistance screen again in case he needs help to get his audio going?
Absolutely. Our audio text slide 24 is the first one we should display. 25 is the next one.
Just in case he doesn't come on, this is David Weiss. I believe his point was going to be that I guess there's a cap on how much STRIF the Bureau can take. And he said there was a history of going above the cap, you know, being at $2.50. It would be nice as an institutional owner if we kind of got the right amount so that we didn't start and stop the process. And there is some expense to stopping and starting this. So I think that was going to be what his point is somehow figure out a way to make sure we just don't go over the, I think he said the $25 million cap. I have no idea if that's the real one. That's all I had.
All right. And it appears that we have lost Robert entirely. When he reconnects, would you like to revisit his comment?
We can give him opportunity in future to close. I think his idea was mostly complete. So we don't need to interrupt the normal flow of the meeting. But we can include it in a future comment period, or he can include it in a future comment period if he was cut off. Did you have any other requests for public comment?
That is it for this topic at the moment. Would you like to close comments?
Yes, please. We'll move on then to an update on agenda item 7D, which is the annual report labor market outcome data reporting.
Yeah, this package is the one required by AB 1340 for schools to collect Social Security numbers of their graduates and then report them to us, and then we report them to EDD to receive wage data, and then the data will be published on the BPPE website for 2 years and 5 years after graduation. The regulatory text pertaining to these new reporting requirements is very similar to what was previously presented to the committee and is very closely tied to the specific data elements required by law to be collected. The changes from the last draft are largely focused on building out our regulations pertaining to our existing annual report process, which we are using for the reporting of this data. Beyond the new reporting required reporting elements, nothing in these regulations would entail changes for institutional annual reporting. We are simply, as a matter of good practice, placing the longstanding procedures for reporting annual reports into regulatory text. At this point, we expect to start collecting data from institutions this year. The package is still being internally reviewed and has not yet been resubmitted to OAL. Does anyone have any questions?
I have a question. I had reviewed it and I had a number of technical proposed changes. And is that something that we should go through now, or shall I just submit that to the Bureau? How do you want to handle that?
I'm not sure.
I think that's up Joseph, or maybe your legal counsel. I don't know if it's appropriate at this time, or if you, or for the staff, if you prefer it this way. I sent it in writing just this morning to Debbie and Richie, so it would be available that way.
Is that understanding correctly that this is a we have previously looked at this language and you're currently updating us on what has already been submitted into the process, or are we earlier in that process in a sense that the advisory committee can offer opinion or feedback? Mr. Dumble, has this already been submitted for approval?
This has already been submitted and is moving through the process at DCA.
And also it is very similar to what was previously discussed. Lynn, did you want to chime in here?
No, I was just going to state that it's up to the chair how he wants to handle it.
So is there in the approval process, which is pretty arcane, right? It goes through multiple steps. We've looked at this language before. It is now submitted. As you mentioned, it's in process at the DCA, Mr. Dumble.
Yes.
Is there another opportunity for the advisory committee to provide, later we're going to talk about expression of will of the group. Is there another stop on the train where that language can be affected, or are we past that point?
I don't believe we're past the point. It depends on what comments we get from the DCA review. If they are very, very happy with the language, I would be loath to upset the apple cart at that point. But if they have some comments, then we could incorporate other comments along with what they suggest.
Okay, Margaret, we received the email with your comment. The advisory committee, we received the email with your comments. I have not had a chance to review. I imagine many of us have not yet had a chance to. But we can look at that for substance, and then you might consider adding it as an agenda item for our next meeting, which may coincide with the DCA process.
I think, yeah, I was going to say, I think since that I've submitted it in writing so the Bureau has a copy of it. And as I said, it's mainly technical things where it seemed to me that there was some contradiction in the language or a lack of clarity or a word that was left out. So it's very technical stuff. So I think it's just fine. They have it in writing. They're free to look at it and consider it if they want.
Very good, understood. I have a question regarding on page 60 in the meeting materials under section D, which outlines the specific time frames for reporting. There's a reference to a notice that the information technology system is updated and is capable of processing the data, which of course was an important milestone in the legislative text, ensuring that this personally identifiable information, the sensitive information being passed on is in a secure system. You mentioned that you feel that the Bureau is very close to implementing this. Have you received internally that certification and are preparing to communicate it, or where are we at in terms of the seal of approval on the IT infrastructure?
We have not received the certification as of this time. The director is aware of this and we're working with the executive at DCA to work out the exact timetable for certification.
Understood. And then I see that we as institutions have 120 days following receipt of that certification then to report retroactive to that 2020.
Yeah. They don't have 120 days to report. They have 120 days to comply. So it could be that the date of compliance is tied to the annual report submission process. They are in compliance if they are still awaiting to submit the annual report at a later date. And so the statute was very specific that it's 120 days to comply with the reporting process, not to report the data.
Understood. Thank you for the clarification. Advisory committee, any other questions for David on the annual report labor market outcomes? Hearing none, we'll open for public comment on agenda item 7D, the labor market outcomes data reporting.
We are now taking public comment on agenda item 7D. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. If you are a dial-in user, please dial *3 to raise your hand, and we will take comments in the order that they are requested. Let's take just a moment to see if we have a request for public comment. Seeing no requests for public comment, would you like to close comments at this time?
Yes, please. All right, we'll move on to agenda item 7E, which are the regulatory proposals based on the 2021 statutory language. And there are 3 Romanettes we'll cover here, 1 through 3.
Yes, first of all is a rather technical change. Last year, the legislature passed SB 607, which was an omnibus education bill. And the bill, among other things, deleted references to ability to benefit exams by repealing sections 94811, 94904 of the Education Code and amending section 94909 of the Act. As a result, we are removing references to ability to benefit tests in 4 places in our regulations where they are mentioned. These deletions are largely non-substantive. The Bureau sent a notice to institutions after the passage of SB 607, specifically regarding 71770. We reminded institutions that even though the reference to ability to benefit test was being deleted, institutions are still responsible for establishing their own admission standards for each program, and that they are not allowed to admit students who are obviously unqualified or do not have a reasonable prospect of completing a program. Otherwise, the other deletions of ability to benefit references in our regulations are mostly non-substantive. Are there any questions?
I have some comments on this. In general, my comment is this: what the legislature did is it removed the requirement for ability to benefit test for non-high school graduates. It did not say that schools could not use an ability to benefit test as one of their admissions requirements. And in fact, if they're a Title IV school, that isn't one of the ways or what the primary way I think that most schools do determine whether or not a high school graduate can be enrolled in order to be still eligible for Title IV. So I also submitted comments on this, on these sections, and what they do generally is basically make clear that when the school is setting standards for admission, it can admission requirements. It would include minimum levels of prior education, preparation, training, and I added or testing, because obviously testing is one of the ways that schools can determine who should be admitted. So it is no longer a requirement, but I think it would be helpful to list it there so that schools realize that, you know, we're not saying this is not one of the ways you can use to make it very clear. So that's what I've done in the various places where that was removed, is just to rephrase it so that it is clear that that is an option for them. And then the other one is on 71770. I think the wording needs to be changed there a bit from what was proposed, because it deleted a portion of, I believe, section oh no, I'm sorry. That's in 71920, I believe, where it talks about. It has 2 sections, one of which refers to the records showing transcripts of formal training, et cetera, relevant to their qualifications for admission, and a separate section that talked about verification of high school completion or equivalency. But as I understand the legislation, the second one is no longer a requirement, so that it really is, that is just one of the things that they may do. And again, I changed that so I could say, or that they can use testing, and remove the part saying establishing the student's ability to do college level work such as completion of an ability to benefit test, because the requirement here now is not for a separate standard for ability to benefit. It is simply for the admission to the school, which can include one of these varieties of things. And then finally, on 71770, which deals with the admission standards, it refers to, it uses the word obviously unqualified, which I think legally is not a well-defined term, whereas the usual term one would use is reasonably. And I know this is something that you had looked at in your proposed changes, but I think that it makes sense to use a term that would be more legally sustainable and enforceable. And then finally, that the question as to whether there should be admitted, it right now says about whether they're unqualified or who does not appear to have a reasonable prospect of completing the program. But it seems to me that what we are looking at, since all of these programs are, none of the programs that are under the Bureau authority are for avocational or recreational. They're all aimed at basically preparing people for either higher education or employment, that those should be factors that would be part of what the school is looking for. So anyway, I have included those comments again in writing, which you have and are able to take a look at and consider. Thank you.
And I will just point out that 71770 is a part of the minimum operating standards package that we are in the process of preparing. And so as it works through that process, that's another place where we can revisit the language in 71770.
Thank you. Great.
Rather than Mr. Nguyen, I'd like to see if we could take public comment on the entirety of agenda item 7E. We've addressed so far Romanet 1 under that section. Can we go through 2 and 3 and then do public comment for all 3?
Yes, you can.
Very good, thanks.
All right. The next one is change in ownership. And since submitting this and putting it on the agenda, we have done additional research, and we no longer believe that we need to propose regulatory change to implement the statute. We believe the statute is self-implementing, and we do not anticipate going forward with the proposed language that we submitted at this time. Are there any questions?
Yeah, can you explain that a little bit more?
Okay, the statute, SB 802, amended Education Code 94885.1 and 94885.5 to say that it prohibited an institution from seeking a change of ownership while in the process of being accredited. After doing some research and review of the language, we decided that there was no need for us to implement a regulation that merely echoed the statutory language. The statutory language is a prohibition in and of itself, and we really do not need to make any changes to our regulations or to our change in ownership form in order to implement the statute. So that's why we decided at this point we are leaning to not proceeding with any regulatory changes at this time.
I have a question or concern related to that as it relates to the nuances of institutional accreditation, especially, and what the term "in progress" might be referring to. So a number of accreditors, for example, have a provisional accreditation status, which an institution would be under that initial accreditation or provisional accreditation status for often a number of years until their first full site visit to receive a non-provisional accreditation. So I believe that there may be some need for regulatory language depending on I don't know if there's enough specificity in the statutory text to differentiate between somebody who has applied for accreditation and an institution who has been granted initial accreditation or provisional accreditation, for example.
That sounds like an excellent point. Again, we are not set in stone on any of this. We are in the process of going through the what regulatory language would be needed, and if That sounds like a good point. We might want to revisit that, but at this point, that's,
So yeah, so I would
so.
encourage dialogue internally with staff in that regard to determine how would the standard of in progress full accreditation, as it's listed there, what does full accreditation mean? Because different accrediting agencies have different definitions of that term.
Okay, we will look into that definitely.
I'm sorry, but can you, and you don't have to do it now, but maybe just send an email later or something, point me the particular provisions that you're relying on when in your thought you don't need the regulation? Particular subsection of the relevant statutes.
We weren't looking at any particular subsection. We just looked at the statutory language in SB 802, and we did not see any clear place where there was the need for more specificity than what was provided in the statute. To the extent that maybe we have overlooked some ambiguity in the statute, that's certainly possible, as Mr. Holt suggested. But just in our looking at it, we thought the statute was clear enough on its own language that we did not think it required any addition to our regulations or any change in ownership form.
And to be clear, I think that the statute is actually relatively clear. It's accreditors that are not. So the ambiguity is not so much in the statute as it is how the statute would apply to accreditation standards that use a broad variety, or accreditation statuses that use a variety of terms that could reasonably be interpreted as in process rather than complete or full.
Okay.
So
again,
could I chime in really quickly? So the sections, and I'm not totally, I think I understand some of the points, and we can obviously follow up after the meeting as well. But to clarify, this 94885.1 and the 94885.5 are the sections of the law that apply to the institutions, degree granting institutions that need to have accreditation. So it's related to those in particular. And just for clarity's sake, because I actually was curious enough about this, I pulled up the statute itself, because I think it might help explain why we ultimately concluded that we didn't potentially need regulations. The statute says an institution, it's within those sections, an institution that's pursuing accreditation under this section shall not make a change in ownership, change in control, or change in business organization form pursuant to sections 94893 and 94894 until the institution obtains full accreditation. So as you can see, we kind of just took that same statutory language and put it here. It's almost verbatim. It is basically verbatim and therefore likely redundant.
I'm sorry, but can you just tell me what subsection that is if you have it in front of you? Because I was searching for it in my copy here and I couldn't find it.
Yeah, so I am.
Never mind, I can just look later.
I know. Well, I started originally looking at my old version too, and of course it's not there because it's newly the law as of January 1. So
that's all right. That's all right. I can look later. I don't want to trouble you.
Okay. So I guess in terms of the questions that Joseph is asking, I guess I'm wondering if it is. I don't know if that makes it feel like there is less ambiguity or whether this is in fact this potential source of ambiguity.
Yeah, it comes to the interpretation of pursuing accreditation and whether WASC, for example, that offers initial or provisional accreditation for a period of time, if you're still pursuing it or if you in fact have achieved it. And so that's something that I'll look at the underlying statute as well, particularly those references, the 948 references, and then you can follow up in an email on that topic.
Thank you.
Any other committee questions regarding change in ownership, the presence or absence of regulatory language to clarify 71640? Very good. Mr. Dumble, could you go into Romanet 3, the educational programs, less than 32 hours?
All right. This was mentioned earlier. SB 802 also contained a provision that excluded this from the statutory definition of an educational program any program less than 32 hours in length, and that was not designed to lead to employment. In order to implement this new language, we are proposing to add the definition of educational program to the regulations. The proposed regulation begins by restating the statutory definition in Education Code 94837, and which adds that a educational program excludes a single course, workshop, seminar, continuing education course, or other instruction that consists of 32 hours of instruction or less, is not an educational program unless it is designed to lead to employment. The proposed regulation then goes on to offer a definition of how to determine if an educational program is designed to lead to employment. This definition was discussed at the recent town hall meeting. What was offered at that point was what you see in the proposed regulation, that a program is designed to lead to employment if it is eligible for federal or state funds that support career training, including but not limited to the Workforce and Innovation Opportunity Act, is on the educational training provider list of the Employment Development Department, is advertised as leading to employment or a career, is that the program enables entry into a new professional field. The program is part of a set of short-term programs that collectively lead to employment, or is designed to prepare graduates for licensure in a specific professional field. As previously mentioned, this was discussed at the January town hall meeting, and at that time, we did not receive any critical feedback regarding this approach. Are there any questions?
This is Margaret. I had a comment. In looking more closely at the language which is in, whether I had a technical suggestion also, again, that's included in what I sent, but one of the criteria is that it's advertised as leading to employment or a career. Advertised is sometimes used in a very narrow sense and causes problems when you're trying to enforce a statute that uses that language. There is a phrase in the definitions in 94868 of offer to the public, which includes advertise, publicize, solicit, or recruit. And I think it might be good in this regulation to use that defined language rather than advertise, which is not defined. And sometimes people try to interpret it as a very narrow thing. You actually put an advertisement in some place, which may or may not apply. And then the other one, and again, this is more of a technical nature. In 94847, there's a distinction made between license and exam preparation and programs designed to instruct students in the skills and knowledge necessary to satisfy the qualifications for licensure. I think that what this is getting to is the latter of those two. And I am again wondering if it wouldn't make sense to use that defined language rather than have some language of slight variance here. And again, that's in the written stuff I sent.
Yes, those seem like very on point suggestions, and we'll certainly consider them going forward.
Any other questions from the advisory committee on 7E3? Okay, thank you very much.
I have well, yeah, that's right. I think it's something for a future meeting. I'll raise it at that time. Thanks.
Very good. Thank you, Mr. Dumble. We'll open to public comment now. And inbounds for this public comment is 7E Romanets 1, 2, and 3, which again cover ability to benefit language, the rescission of that language from the regulatory text, the change in ownership reference to accreditation process, and educational programs less than 32 hours. So if you have public comment on any of those 3 items, please do so now.
We are accepting public comment at this time. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of your screen and send that comment to all participants. If you are a dial-in user, please dial *3 to raise your hand. We will take comments in the order they are requested. All right, let's wait just a moment to see if we have a request for public comment. Seeing no requests for comment at this time, do you wish to close comments?
Yes, please. And we'll move on to agenda item 7F and discussions on two topics, the out-of-state registration application and criteria, and then separately changes in signature requirements. So, Debbie, do you want to start with the first?
I'm actually going to have Yvette Johnson walk us through these.
Okay, great.
Thank you.
Hello all. Okay, so our first item for discussion is the consideration of out-of-state registration applications. So effective July 1 of 2022, AB 1344 expands reporting requirements for out-of-state institutions required to register with the Bureau. It also provides the Bureau the authority to deny or place restrictions or conditions on registrations for out-of-state institutions based on information provided to the Bureau. In your package, you'll see you have a copy of the memo as well as a copy of the bill regarding this issue. And we invited discussion on the bill implementation at one of our previous advisory committee meetings. The Bureau proposed a draft form for discussion, and it was presented at the August 26th advisory committee meeting. As the form is currently going through the regulatory process, we invite further discussion on the second part of the component of the bill, which was how should the information gathered from the form is to be used to make decisions about whether to deny registration or to place a condition upon it. And with that, the Bureau poses the following questions to the members of the advisory committee of the advisory committee when considering the drafting of the regulations. So if you refer to the memo, you'll see our 4 questions that we would like to pose. And so I'm opening up the floor for discussion on that. With our first question, it is, what situations would warrant a condition being placed on a registration for an out-of-state institution?
I can start and offer some feedback. I think for both questions 1 and 3, the 2 standards I think you should keep in mind as a guiding principle are materiality and relevance. So what is the materiality, which is addressed incidentally, it's addressed with that $250,000 standard referenced in regards to an outstanding judgment. But some analog for that is this issue that would determine, is it material in terms of its scope, particularly in light of the institution or program. So materiality is one. And then the second issue would be relevance. So an out-of-state institution applying for registration in the state of California is going to be offering presumably some, potentially all of its programs, but potentially some subset of its programs or even a subset of institutions operated by the applicant. And so I think that it's important for the Bureau to look at what is going to be offered to California students from this institution or enterprise, and is the piece of concerning information or the area that is cause for concern, is it A, material, and B, is it relevant to the consumer protection of California residents? Is it something that is going to be offered here? So therefore, if a college offers a program out of state in another state that has issues or causes for concern, but they're not offering that program or anything like that in this state, I think that would be a mitigating factor in the awarding of a registration. So to summarize again, materiality and relevance.
This is Margaret, and I have been mulling this in my head ever since these materials came out. And I don't think I have any really good answers. I think that the points that Joseph makes are good points. And I think I would like to spend some more time and we'll hopefully get back to you with some thoughts because I think the crux of the matter in a way is what is the cutoff point between something that we say can go ahead and something we say can't, and how do you decide what that point is, and or how do you decide what the point is between yes you can but with these restrictions, and what restrictions are they? And I frankly don't have any wise ideas to offer at this time, but I'm going to work on it, try to see if I have anything to get back to you with. I think that it's the kind of thing where we do sort of know if an institution is engaged in certain activities that could be a real harm or possible harm, that no, we don't want that happening in our state. We have very little information about these institutions, so it's a little hard to figure out what the criteria are, or how to measure the criteria. So sorry, I can't be more helpful.
We appreciate that, Margaret, and please feel free to send in your comments or your suggestions at a later time. We're just asking that, then a couple of weeks you'd be able to get something back to us.
I'll do my best.
For review and further consideration. We appreciate it. Thank you.
And Yvette, I'll defer to you to lead dialogue through this. So if you want to move on to question 2, or you can solicit from the advisory committee feedback, and I'll let you run the conversation.
Okay. And question 2, what types of conditions would make sense to place on a registration for further student protection? And I know Margaret has stated that she'd like to look at things further. So, and I don't know if the rest of the committee would like to have that same opportunity to just go through the questions, review further, and come back to us at a later time.
I have a couple ideas I can offer now. Increased reporting requirements,
Okay.
Increased frequency and or rigor of compliance visits would be, I think, the 2 probably best suggestions. I know there's been some conversation through the sunset process regarding like surety bonds. If you have a clear identified risks, that would be another possibility. I have some more reservations about that category, but that's another thing that came to mind as a possible condition. Copying from programmatic accreditation, particularly looking at more regular checkpoints. So if you have concerns about something and you're going to approve a registration with condition, maybe having a shorter interval of reporting or checking in on that program more frequently in the near term.
I think that makes sense. This is Lee. I think that makes sense. And I think that also the challenge is figuring out, there could be a number of different types of risks, right? So figuring out how to make the conditions apply directly to the risk that you're seeing. And I do think that's, I don't know that even if we sat here for an hour, we could think of every single potential risk factor that we'd be wanting to look at. Maybe over the course of the next week or so, we can come up with some more ideas. But if part of, as part of that check-in process, I think some communication with the students at the school would be helpful, whether it's anonymous surveys or identified surveys, something to check in with the students on experiences, and then depending on how long the monitoring period would be, outcomes as well.
Thank you. Okay, yeah. There are no further comments on number 2. We'll move on to number 3, which is what are the types of risk factors that may warrant denial of an application as opposed to the imposition of a condition or registration?
I have some notes here looking at a confirmed judgment or a conviction, a confirmed judgment or a ruling, which there may be accusations in process. There are some things that might be cause for concern, but on their face shouldn't be cause for denial. But if you have a confirmed judgment or ruling on something that is both material and relevant, then I think that would be grounds for denial in the interest of protecting California consumers.
I would add to that I think it could be in the form of a stipulated judgment or stipulated outcome, as well as one that's actually determined, because 99% of these kind of things don't ever reach a court ruling, but the parties reach a stipulation, which then maybe enter some sort of required payments, required conditions. So those should be viewed the same way as the determinations you're talking about, I think. And I think that makes sense.
I would argue that materiality is critically important in all of these decisions, and that the Bureau not take the perspective that any stipulated judgment, even for something small or immaterial, would on its face be grounds for denial of a registration. So materiality and relevance, I think, are, as I mentioned in number one, be overarching for all of these areas.
I think some of the other things, again, I'd like more time to sort of think it through, but, being placed on cash collection by the feds would be another one that would have, I think, a fairly high degree of risk. And I think there may be others as well.
That's a good idea, Margaret, like heightened cash monitoring too, for example, or yeah.
Right. There's no further discussion on number 3. We'll move on to number 4. While the Bureau must consider all of the information provided, should certain types or scales of issues be considered to connote higher risk?
The risk of being redundant, I would say materiality and relevance. Is this what they're going to be offering to California consumers? And is it material financial harm? Is there substantial risk, imminent risk for California residents?
One way to look at that may be the number of enrolled students in California, something like that, because, if you have problems with a large number of students, it's going to be much more of an issue of concern, I think. And maybe in those cases, even the potential harm might not seem as great, but if you guys going to affect a ton of people, I think that's a real issue.
I will just chime in for just a moment. This is an incredibly helpful discussion, so really want to thank the committee members for all the feedback. I am just in terms, any feedback. I understand some of these things people want to mull for a bit. Please do feel free to send us thoughts in the coming weeks. And I'm realizing there was a packet, a page in the packet on page 52 that I think we glossed over very quickly. As you all know, we have had different versions of kind of a tracker that show how our various regulatory packages are marching through the progress and expected timeframes. This is there's varying levels of detail that can go into something like this. This is a dialed back one that we're kind of trying out here, but as you can see, we kind of are shooting as a general rule to bring the draft to the advisory committee before moving forward with these packages. So what I want to highlight here is you see this out-of-state institution registration conditions and denials, where we have it slated, anticipated right now to bring, draft text to the committee for discussion at our May meeting. So we will be taking this feedback, any other feedback you all want to submit to us in the coming weeks, but I just wanted to take a moment to acknowledge this high-level tracker and let you know that we will be bringing this back in kind of a fleshed out form for consideration.
Similar to the town hall that you all held, I think this is an excellent way of approaching this, is getting even informal conversational feedback from the advisory committee in this venue in advance of your first draft even, and then when we look at the draft. I think that's really thoughtful and appreciated.
All right. Well, thank you all for your comments regarding this issue. Would you like to open it up for public comment now?
No, we'll take Romanets 1 and 2 together and then do public comment for all of 7F. So
Okay.
you can go ahead now to refer to the signature requirements for substantive changes in application.
Okay. So the next section is the consideration of changes for signature requirements. In your package, you'll find the memo regarding the application signature requirements. And the questions have been raised regarding the various signature requirements for applications the Bureau approves. Signature requirements differ by type of institution, but are the same across all application types. We are seeking feedback, suggestions from the advisory committee regarding whether or not we should make changes to our regulations regarding the requirements for signatures on the applications. We have a few discussion questions, but also welcome other questions regarding the subject. For your consideration, we have the following questions. And once again, I'm going to refer back to the memo. And the first one is, for incorporated institutions, is a 25% interest threshold appropriate? Again, you're on mute.
I think that meets a reasonable standard. 25% sounds like, as a hunch, sounds like a good number. And to be clear, then that's the threshold at which a 25% or greater owner would be a signatory requirement.
Correct.
For corporation, correct.
Yeah, I agree. 25% is a huge percentage of ownership. So somebody who owns that much, they certainly have an important role in that company. If you think about I think securities violations or when securities, can't remember exactly, disclosures or whatever need to be made. I mean, they're looking at 5% ownership as somebody who is significant in the company. So a 25% I think is certainly well sustainable.
Next section is, for nonprofit corporations, is requiring signature from each member of the governing board warranted?
That seems excessive to me. I don't want to always be the first one to chime in. So maybe it's for somebody. I think that seems excessive. I would think that the principal, the chair, the chief executive for the institution would make more sense than like the 8 or 12 members of the board of governors.
Hi, this is Margaret. I think the whole point of having signature by these people is so that people will feel that they do need to be looking at what's going on, that they feel a responsibility. I think there's probably two ways to deal with whatever burden might be entailed if you have a really large board. One way is simply to make sure that things are set up so that people can sign separate documents. They don't all have to be signing on the same document, and that you can do it by DocuSign, so that makes the process pretty easy. The alternative that would be that they would have to sign at the beginning of their tenure and have it apply to their whole tenure on the board, a statement that they relinquished their authority to sign for these things to X people, and that they agree that they will be bound and liable to the same extent as those people for anything where that signature was applied. So that you don't actually have to go around and get everybody's signature but you do have them basically still liable, responsible for whatever that organization does. And some people may prefer not to, give someone else authority for them in essence and still sign. But I think either of those two might be a way to deal with it. But I think we don't want people sitting on governing bodies who are just there for the resume. We want people who are really looking at the materials, at these submissions, and making sure that this organization really is living up to its responsibility.
Thank you. Any further comments on that one?
Yeah, this is Kevin Powers. I have a comment. Well, a question and a comment. So when we're looking at the signature requirements, do we know what kind, can these be electronic signatures or do they have to be wet signatures?
Debbie, you want to take that one?
Sure. So our regulations specifically that we're looking at here don't speak to wet or electronic signatures. That is an issue that has been brought to our attention, and we are, and it's one that we've been taking a look at, and it's something we hope to have more to say on in the near future. But that's pretty much where we are now. It's another important issue, we know, but it's separate from this one.
Great, thank you.
In relation to that, I would just mention, I think I mentioned it in the written comments also, when you are looking at being able to use electronic signatures, I know there's both a federal statute and a state statute on use of electronic signatures. I know it applies in consumer and other business transactions. I don't know if it applies to the state, but obviously that's something that your legal folks should look at in connection with this.
I was just going to make a similar comment that while I understand that there's separate considerations, there is some crossover in that the burden of having an entire board of governors sign something is a little different when you can send it out via DocuSign compared to when you have to get, 20 different people to mail something in. I mean, if you ask me to mail something in, it's going to take me a while. If I have to electronic sign it, I can do it in 5 minutes. So I think there is the burden question is related to the format to an extent.
Thank you. All right, the next one is, should required signatories be allowed to delegate signature authority to another individual or individuals?
This is Margaret. I think my prior comment spoke to that.
I would agree.
Lee, we couldn't quite hear you.
Sorry about that. My microphone is not catching my voice, or I'm muttering or something. I said I would agree with your comment, and I would say I wouldn't allow people to delegate the signature requirement.
Are you willing to let them delegate it if, or what my suggestion was is yes, they can delegate it, but only if they have signed something that basically makes them as responsible and liable as the people to whom they delegate it, and that stands for the whole time they're on the board.
Yes. I mean, I guess part of me is like, then why delegate if you're already signing something else? But I guess yeah.
Yeah, I think as you, on the next page in the packet, you can see the variety of type and kind, and there's currently a single requirement for all the different kinds of applications. And so that, I understand Margaret's point that if you serve on a board of governors and you're going to make applications every quarter for one of these items, then it might make sense just on a repeated basis to do a once for all signature. Although I don't know how to sign anything that empowers someone else's signature to count as mine. I don't know, but I don't know that I would do that.
I agree. I wouldn't do that either. But some people may want to, but we would need to make sure that whatever it is they're signing is well laid out so that you know that they in fact will be held responsible or liable for violations, etc.
Any further discussion on that topic, on that particular one?
This is the moderator. Kevin Powers has his hand up.
Sorry about that. I'll put it down. My question was already addressed.
Kevin, okay.
I read that as a high five, Kevin. I think you're good.
It works either way.
All right, and the last one is, should all application types have the same signature requirements?
Hey, I would say no. And that's a great question and is really one of the root causes of the tension that you're experiencing or the pushback that you're hearing there. And so I have a kind of a color-coded list of those that I think should require that principal signatures and just I can email that and follow up. I don't know that I need to go through each one right now, but I think they are very much differentiated in terms of degree of importance.
Joseph, could you, we would welcome that email. Could you just say, kind of give an example of like one that the ends of the spectrum?
Sorry, toggling screens, needed to unmute. Yeah, so all of the first four bullets, approval to operate, approval accredited, non-accredited, and to renew an operation, those come up infrequently and are also obviously critically important. So I would say they're absolutely principal signatures. Examples of in that second bullet that I would say shouldn't require principal signature would be addition of a separate branch, change in method of instructional delivery, increase or decrease of 25% more on clock hours, a change in distance education learning management system. Those things are typically handled, for example, by operational and or academic staff typically that and a lot of those changes happen as a matter of course in operating the institution, and the owners or the principals or even the board of governors won't typically say, hey, we're going from Moodle to Blackboard, right? Like they're not really involved in that level of decision making.
I have a problem trying to figure out how to differentiate, because in the general run of schemes with good schools, what Joseph said makes sense. The problem I have is that we have seen schools where some of these changes can make gigantic differences in the way they're run, including such things as adding a separate branch. You have someone who buys a small nonprofit college, and once they've got it underway, suddenly they have added 15 branches all over the state, and there's no control, and the place falls apart. And you can look at almost any of these and you have the same situation. They change location and represent that it's 2 miles away, and that's signed off by one person or two people. And in fact, you later find out, no, in fact, they moved it 25 miles away. There's no easy bus connection, et cetera, and people are left high and dry. So my problem with all of these is that most times they're probably not significant, but in a problem school, any one of them can be really significant. And so I think we would be better off trying to deal with it by some of the other solutions we've talked about, which is the electronic signature or giving authority, because you really do want people looking to say, oh, this says such and such address. That's not 2 miles away. What are we doing? So it seems to make sense on its face, but then when you look at it, I can think of all kinds of examples that I have dealt with in prosecuting schools where it was one of these kind of changes that really harmed students.
Any other feedback for Ms. Johnson on changes in signature requirements? Yvette, did you have any other questions for the advisory committee?
Not at this time, but I thank you for your comments and your feedback. And please, if you have anything further, please send that to us.
Excellent, thank you.
Thank you so much.
We'll open to public comment this time for agenda item 7F. Was the advisory committee discussions and feedback to Bureau staff regarding out-of-state registration applications and changes in signature requirements.
This is Moderator. We are now open for public comment. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of your screen and send that comment to all participants. If you are a dial-in user, please dial *3 to raise your hand. We will call on people in the order that comments are requested. Let's take just a moment to see if we have a request for public comment. Our first request for public comment comes from Angela Perry. Bear with us just one moment and we will send you a request to unmute your microphone.
Hello all, Angela Perry, the Institute for College Access and Success. Again, just really want to sincerely express appreciation for the transparency and the opportunity to discuss these regulations publicly and to hear the thoughts of the advisory committee members. I also really appreciate the Bureau asking for any comments to be sent in, and I'll try to convene with some folks and see if there are any thoughts or input that we can get from student advocates as well. But just sincerely want to express appreciation for all of these updates, for the new tracking system, the increased transparency around regulations, and the real importance that this really important part of regulation has been given. And I just really wanted to express appreciation to the staff, to the leadership, and to the advisory committee. So thank you again so much, and we'll try to get you thoughts as soon as possible on these regulations and all of the things that have been discussed at the recent town hall, etc. Thank you again.
Thank you.
And that appears to be our only request for public comment on this agenda item. Do you wish to close comments at this time?
Yes, please. We will move on to agenda item 8, which is a discussion of reasonable rules and the conduct of the advisory committee of affairs, which are come from SB 802 passed last year.
So I will open this up, but really I think this is a conversation for the advisory committee members to have. As you know, SB 802 did require that the Bureau to adopt reasonable rules for the conduct of its affairs. And we have something along those lines in the form of the advisory committee handbook, which we have put in its entirety into the packet. It was last revised just shy of 2 years ago, but that doesn't mean there's not still room for improvement. Of course, with the SB 802 changes to the election cycle, that will trigger some important changes to be made to the handbook. But really wanted to see what this group would like to see in terms of additional rules or provisions in the handbook or modifications that might seem fit.
For my part, I appreciate going back and reading the handbook, which I hadn't done for some time as you initiated this conversation. And I didn't see a glaring need for additional rules per se. I can see a gap over the last 5 years that I've been on the board in terms of more formally holding to the handbook, specifically in regards to the expression of collective will. I feel like that's an area where maybe we have the largest gap, that Bureau staff probably gets a pretty good cross-section of opinions from individuals on the board, but it's very rare in the last several years that we've actually resulted in any sort of motion, which would require then a vote of the board and constitute, according to our handbook, an expression of collective will, which I think we just have tended more to the informal side. And so I don't know that we need new rules of the road so much as maybe we just need to lean into the ones that we already have. As a quick qualifier for that just as well, I would say that there has not been a lot of opportunities, or there haven't been a lot of instances where Bureau staff is looking for formalized feedback from the advisory committee. They've been more conversational in nature. And so I think that it's kind of two parts, the advisory committee and our actions, but then also Bureau staff and what information are you approaching us with and in what context. And so I think by improving both of those and holding a little more to a formal process to express collective will on matters would go a long way towards meeting the spirit of that statutory directive.
This is Margaret. A couple of comments. One just more of a technical nature. In the handbook, on page 7 of the handbook, which is 92 of our materials, it talks about in the middle of the paragraph on purpose, members should be concerned primarily with formulated advisory recommendations regarding Bureau policies rather than so forth and so on. I think that's actually not correct when you look at the statute, which says that it's regarding Bureau policies and practices. So if you are going to maybe any changes, I would just make that change to the handbook so that that is accurately reflects the statute and what the intent is. As to the rules of order, I noticed that I think, as I recall, not having read them for a while, Robert's Rules of Orders typically require a motion first and then discussion. And the handbook lets us have discussion first and then a motion if we want. And I think that's ideal, the way we've been handling it. As far as we're taking a motion, having a vote, I have been very impressed with the ability of the members to express opinions and then the staff to take those and put them together with their expertise and then come back with, here's our proposed regulation, and then we are able to discuss that. I think that in some cases, sort of forcing us into a collective view of something maybe is counterproductive, but it seems to me the rules are flexible enough so that if anyone wants a motion, we're certainly free to bring a motion. And so in those instances where someone feels like, gee, I really want to have this, on the record that we move to do such and such, I think we have that ability. Or if the staff really wants that, they certainly have the ability to ask us to do it that way. But I do like the flexibility so that, we are able to discuss, provide opinions, and then if anybody wants to, they can make a motion to have a collective view, but otherwise the staff can take it all in. So I like the handbook. I think this handbook recommends that, but it's certainly not a requirement. So I think that we're fine with that. And they work pretty well, the rules.
One observation I will make just on the point of the collective will, it's, I know it's come up a few times today about kind of us trying to put out things early for feedback, and, trying to loop back as much as possible. And, that is, I think that's something that it seems like folks generally feel good about, but it also involves a level of judgment in terms of what should get brought, what needs discussion, what just can we put out on a draft, and what is so straightforward we should just move forward. I think, you can see a value to either way, but kind of having both the kind of early, purely advisory opinion role and then needing to come back later until we get to a kind of a collective will. If we were looking at trying to hit both, that would seem to slow us down in terms of our ability to make headway on a number of issues. So just there's a tension there that I see.
Have you observed best practices within the DCA of other bureaus or boards that have, I guess if as a board, it wouldn't have an advisory committee, but how unique is this advisory committee set up within the DCA structure?
It's a great question. I know Carrie Holmes, I'm not sure if she's still on and listening. She might be able to say something. What I can tell you is that I have been asked a couple times to share some of the memos that we've drafted as a staff, kind of for consideration for other advisory boards or other advisory committees with other bureaus, just as a kind of a sort of a good practice. So I think all the bureaus, separate from the boards, which have a different set of rules of engagement, I think are probably struggling to some extent with similar questions about how to really make use of the expertise that they have. I mean, I know just for myself coming on board, I find the early input incredibly valuable. Many of you on the committee know that I will sometimes call and just try to pick your brain on things. And I heavily rely on that early feedback.
I think the other thing is that the recommendations that have been sort of incorporated in here and what they talk about as far as collective will, we have to remember that the GCA is sort of thinking about all their different boards and bureaus. And boards actually have to or need to take votes to determine, whether they're going to revoke a license or suspend someone or so forth and so on. So I think that the recommendation or advisement there is really sort of to capture the overall picture, which some of it may or may not apply to us as an advisory committee.
Yeah, I think that's a great point. And something I struggled with a little bit in looking at this question broadly is if we take a motion and we vote one way or the other, we express our collective will that isn't binding in any particular way to the chief or the staff. Like ultimately you're soliciting feedback. And so not to delegate too much, but it's almost like what would be most useful for staff, right? And so I could see if you have a highly divergent, opinions and this person thinks this and this person thinks that, and it's hard to see the forest for the trees, then you might want to have more formal motions where you see an expression of collective will. But ultimately it's your decisions. The bureau staff and you as in leadership need to make those decisions, and we're an advisory, board, even if we take votes, right?
That's definitely something we can take back and think about, but it sounds like maybe as we are, I was going to propose as the next step for this to take whatever feedback comes in on the handbook, potentially suggest some amendments and then put in out back for reaction. But maybe that balance is something we can take a look at as well of making sure we are striking the right balance that feels like it's kind of making both sides feel like it's a productive relationship. Any other comments? Probably ready for public comment on this one.
Very good, thank you. We'll go ahead and open to public comment for agenda item 8, the adoption of reasonable rules for conduct of the advisory committee.
We are now taking public comment on agenda item 8. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of your screen and send that comment to all participants. If you are a dial-in user, please dial *3 to raise your hand, and we will call on people in the order that we have requests for comment. Let's take just a moment to see if we have a request for public comment. Seeing no request for public comment, do you wish to close comments at this time?
Yes, please, thank you. Very good, that moves us to our last agenda item, which is a discussion on future agenda items. So the advisory committee members, now is an opportunity to bring forth items you'd like addressed in our next or future agendas.
I think someone had mentioned earlier, it would be helpful to sort of break out the cost of closures on the Bureau in relation to what kind of bonding would be useful. My experience with bonding has been that often the bond is put in place and then it's never big enough to really handle the problem. So I think the idea of having some financial analysis of what that costs the Bureau to deal with school closures is a good idea that we might have some more information on for next time. The other one I suggested having some more information on was the relation between the federal requirement for complaint handling and the contract complaint handling with the state. Maybe just kind of an informational thing, if the Bureau could provide something like that for our next meeting. And then another thing I have is the under 32 hours program is no longer requiring approval. What I envision as an issue there is schools that are approved, but then are offering a bundle of, or a ton of basically under 32 unit programs or courses or whatever you want to call them that have no oversight. And yet for students looking at the school, the advertising not being clear as to, you know, these programs are actually approved programs and these, you know, you're really on your own. And I don't know that there's anything that can be done by regulation on that, but possibly under the statutory requirements to protect the public and also to not put out misleading information, whether there could be something done by regulation or if not, perhaps a recommendation for statutory change so that the schools or the programs that are not under the Bureau, the approved schools would have to at least provide for those some kind of a one-page thing that says clearly, you know, we're approved, but these programs are not under approval. Nobody's overseeing these, just so you know. Something along those lines, that maybe we could discuss that. I think that's it. Thanks.
Following up on a comment from earlier in the meeting, I think included in the STRIF, it wouldn't be a separate agenda item, but in the STRIF update at our next meeting, if we could see modeling of the accrual of a 250 per thousand, which I believe is the statutory maximum, is the reason that was chosen. But given known collection rates or head count of enrollment, how quickly we anticipate, or at what rate, what would our annual revenue rate, what is the anticipated annual revenue rate? So some forward modeling. Looks like you have about 9 million in outstanding liabilities with the remaining Silicon Valley College. And so I know it's a lot of guesswork, but to address an earlier concern, some more forward-looking modeling on the STRIF would be helpful.
I'm sorry, there's one other thing too. And I have been asking continually about the IT program going forward and how accessible it's going to be to students and so forth. And I guess as I'm listening to the conversation today, I'm realizing my question is probably not correctly directed, because the issue really is, how is the website going to be changed? And I'm gathering that that's not something within the ballot we could, the people putting the IT program together. So among your mountain of tasks, it would be nice that sometime in the near future, we could have sort of what's being done to look at the website and changes in it, and kind of a time frame as to when you think that might happen, so that we would have a website that would be much more friendly to the public. Just one more thing to add to your list, Debbie.
I would agree with that agenda item, Margaret. I share a lot of your concerns about having a website that's user-friendly for any student or anyone who's helping a student look at the end of these colleges. I think it would be nice if the website was a lot more user-friendly for anyone who might be doing that research. It's definitely on the list. It's definitely, yeah, on the list. And like I said, I think the staff would be highly supportive of a much improved website. And I think the question is kind of how many iterations do you want to do versus wait until we've got the kind of better data, whether it's the full shift to Connect or getting annual reports into Connect, or, you know, there's kind of a number of iterative steps that are happening, each of which opens up new possibilities. So it's a balancing act. Definitely a point taken.
Advisory Committee, any other suggestions for future agenda items?
The other thing, and it's just an informational thing, so I don't know if it needs to be a whole agenda item, but I had the question about how far back sale goes, that the information is being transferred over. If we could get some response on that, and it can just be, if you can do it that way, just an email to everybody, or I suppose a short agenda item.
Oh, another one that you brought up earlier, Margaret, was the number of, it's like more than 90% of the contracted institutions, those, they're not able to reach resolution, I think was the phrase used in the report. So within that complaint investigation report, including maybe some more color commentary on what is the productivity or effectiveness of those contracted, if we're not able to reach resolution.
Right, and that kind of ties in with my request for sort of a little presentation on the interconnection between the federal statute requiring complaint handling and the state contract complaint handling solution, and is it fulfilling what's required? And if so, yeah, that was the whole question about not a lot of them being resolved. Thanks.
Okay, not hearing any more here. Question for Mr. Nguyen, do we do public comment on future agenda items? I don't remember.
We should, yes.
Okay, very good. So we'll go ahead and open to public comment for agenda item 9, future agenda items.
We are now taking public comment on future agenda items. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of your screen and send that comment to all participants. If you are a dial-in user, please dial *3 to raise your hand. Let's take just a moment to see if we have a request for public comment. We have a request for public comment from Angela Perry. Bear with us just a moment and we will send you a request to unmute your microphone.
Thank you so much, Angela Perry with TICAS, for my last comment of the day, I promise. Thank you all so much for a really productive, very helpful meeting. In terms of topics, I think that many of the topics that have been proposed for the future meeting would be fabulous. One I will echo in particular is data on or information about the cost of school closures to the Bureau. I think that would be really helpful. Also, information about not only the complaint processing sort of generally, but also some information about the internal process by which the Bureau handles complaints, sort of what the process looks like once a complaint is in the Bureau's hands. I think that would be incredibly helpful. And just generally, one suggestion is, I know that as we're undergoing the sunset review process, it is a little bit, to use the colloquial term, a little meta to have a conversation about sunset review, but it might be helpful to, as that's moving forward, if there could be updates or discussions of the addendum or any of the recommendations as those are potentially incorporated into the sunset review process. I think that might be another interesting thing to have an update on at a future meeting. But truly, again, thank you sincerely for all of the help today, all of the wonderful information, and a sincere thank you to the Bureau staff and leadership and the advisory committee for the wonderful meeting. Thank you again.
There doesn't. Oh, go ahead, please.
I'm sorry, this is Margaret. I just remembered another issue I wanted to raise for future agenda items. Is it too late for me to raise that now?
Go ahead, Margaret.
I had, I think, mentioned this before, but one thing that has always disturbed me is the required sunset of an agency that we all know needs to be here in perpetuity. And sunset review or review of an agency every so many years makes a lot of sense, but actually the statutes ending the agency, unless the legislature votes to reinstate it, I've always found to be crazy, among other things. And I would be just curious if there would be support to put this as an agenda item to see if there's support among the committee members to recommend that the Bureau recommend to the legislature that the periodic review not include a sunset itself. And that I know is probably impossible because they do it to all these agencies, but it's just one thing that agency's been killed at least twice, and we've been left in limbo because of the sunset requirement. So I suggest that as an agenda item for us to discuss, see if we do have any sense of that the advisory committee wants to take a position on that.
And it looked, David, like we didn't have any more public comments queued?
There are no more requests for public comment at this time. Do you wish to close comments?
I do, yes, thank you. Very good. That brings us to the conclusion of our meeting. Deborah, did you have any closing thoughts or comments for the committee?
Joseph, you did a great job for your first meeting.
Oh, thank you.
I agree.
Absolutely. Congratulations, Joseph. Well, and definitely look forward to continuing to work with you in this new role.
Excellent. All right, thank you, everybody. We will officially then adjourn our meeting. Thank you all for your contributions, and everybody stay healthy and safe.
Okay, bye-bye.
Thanks. Bye.
Bye.